Hi, Andy Nelson. Today I want to talk about an 8th way that you can torpedo your trademark rights. And this specifically deals with trademark rights that are wrapped up in a federal trademark application. If you're looking to obtain registered rights, this is a way to really screw up what you're trying to do. And this is what it comes down to: choosing the wrong class of goods or services. Now, the way that the USPTO, United States Patent and Trademark Office, registers trademarks is in connection with certain classes of goods or services. You don't just register a mark for Michelin and say, I own Michelin for every product or service under the sun conceivable. It doesn't work that way. It's you get rights that are tied to the types of products or services that you have offered and may offer, so long as they bear kind of a natural expansion of what you're already doing. They're reasonably related. So, dental insurance, health insurance. Dental insurance, but not tires, okay? So that's kind of how it works. So here's what happens a lot of the time. A lot of would-be trademark owner applicants attempt to register trademark rights on their own. A lot of folks are successful. Many folks are not. And here's one reason how they're not. They will often apply to register their goods or serve their mark, basically, in connection with the wrong goods or services. A couple of examples. Software can get confusing. A lot of folks have web-based or digital services, and it can be tricky to figure out which class you should be in. And one is actually not a service, it's actually a goods class. So downloadable apps, for example, that's a good, that's considered a product. And that goes in one of the goods classes, and I'm just gonna tell you, it's class 9. But a lot of folks will register it in a services class up in the high 30s or the early 40s, which is wrong. So that could actually, it won't completely torpedo what you're doing, but it could impact the scope of your protection. And frankly, it could be inadvertently a fraudulent application in that it's the statements you're making to the trademark office are incorrect. That's one. Here's another example. I had somebody apply. A lot of people, of course, have apparel-based businesses, clothing manufacturers, even a lot of small businesses. But some people inadvertently choose not the apparel class, but the textile class, which is something different. Or how about this? Hard alcohol, beer and wine are in different classes. So you got to watch that. Now that one's an easier one to not screw up. Hopefully someone would figure that one out. But some of these others are not so clear, and they can even be challenging for lawyers at times. Some we know. Others, we get a product or service, and we have got to look it up a little bit to see where it belongs. But a lot of folks do get these in the wrong place, and they are sitting on basically time bombs because they have registrations that are probably incorrect, fraudulent, and don't offer the right protection anyway. So when it comes time to enforce a mark, all of a sudden you've got registration problems you didn't even know you had. And that can really torpedo your ability to enforce your mark in the long run. Now, I just gave you a couple examples. There are many, many more, and I bet if any trademark lawyer watches this, or maybe somebody who's gone through this process, you'll probably be able to add some comments on what your horror story is. Anyway, that's it for today. If you have any questions about this video, shoot me a note, drop a comment, and if anybody you know would benefit or may benefit from the contents of this video, please feel free to share it. Until the next one, have a good one.